I just discussed with the ranking member, if it's okay now that we have 7 here, we can go ahead with our speeches. And when we get 9 people, but we have to have at least two from whatever political party to be here in order to hold over. But my goal would be to start out my remarks, and when we get the right number of people here, to make sure that we stop and hold over. We already have several computer stations set up. Hey, wait a minute, this is page 8. There you go. You shouldn't do that to us.
Mr. Chairman, would you yield for a question?
Yeah.
Do you have plans for us today to vote on U.S. attorneys?
If we get 11 people here, but we got to have more than the 9 to hold over, but at least to hold over.
Okay, thank you, Mr. Chairman.
Today we have 12 judicial nominees on the agenda, as well as a nominee to serve as Director of the National Drug Control Policy. At the request of the minority, we'll hold over the nominees. If we have enough members, we'll vote on the 3 U.S. attorney nominees. Before we turn to today's agenda, I'd like to speak briefly on the Supreme Court nomination. Over the past few days, several of my Democratic colleagues issued statements demanding that Judge Kavanaugh's confirmation hearing be delayed. They claimed that this is necessary because President Trump's former lawyer recently pleaded guilty to criminal violations of campaign finance law, allegedly at President Trump's direction. But the Senate Democrats are not united in their demand for delay. Senator Manchin, for example, wants Judge Kavanaugh's hearing to proceed as planned. I agree. I'm not going to delay Judge Kavanaugh's confirmation hearing. There's no precedent for delaying the hearing in these circumstances. In fact, quite the opposite. There's a clear precedent pointing the other way. In 1994, President Clinton nominated Justice Breyer to the Supreme Court. President Clinton was, at that time, under investigation by independent counsel Robert Fisk in connection with the Whitewater land deal. Indeed, President Clinton's own records were under grand jury subpoena, yet the Senate confirmed Justice Breyer during all that goings-on by a vote of 87-9. Moreover, President Clinton was under investigation for much of his presidency and was eventually impeached for committing perjury, but the Senate didn't stop confirming his lifetime appointments to the bench. President Trump is not even close to being in the same position as President Clinton. My colleagues' pleas to delay the hearing then ring hollow, and I'd like to explain that liberal outside groups and Senate Democratic leaders decided to oppose the president's Supreme Court nominee by any means necessary. Some even announced their opposition before Judge Kavanaugh was nominated. Minority Leader Schumer said that he'd fight Judge Kavanaugh with everything he's got. Some members of this committee announced their opposition before giving him any consideration whatsoever. The goal has been the same, delay the confirmation process as much as possible, and hopes that Democrats take over the Senate after the midterm elections. I'd like to address a few other inaccuracies about the confirmation process. Yesterday, my friend, the senator from Illinois, said that only 6% of Judge Kavanaugh's executive branch documents are available to the public. It doesn't consider the entire mathematics behind this to get to the absurd percentage that was given. You have to assume that the universe of documents includes emails sent by other people in the White House merely just mentioning Brett Kavanaugh's name during the 8 years of the Bush administration. Why would my friend use that figure in his calculation? After all, we didn't receive documents merely mentioning Justice Kagan's name, only those documents to and from her. When you use the actual number of documents we requested versus documents that we've made public, it's clear that a substantial number of Judge Kavanaugh's documents are available to the public. My friends on the other side of the aisle are also claiming that 99% of Justice Kagan's documents were disclosed. Not true. They apply a different standard than the one they apply to calculate Judge Kavanaugh's figures. They don't include the 60,000 or so documents mentioning Justice Kagan's name in their calculation, but they include mention of Judge Kavanaugh's name in saying we only see 6% of his documents. They also don't include Justice Kagan's Solicitor General documents, saying that they're only looking at White House records. This is, I think, very partisan approach, all to distract from the fact that we have received almost 3 times the number of pages for Judge Kavanaugh than we received for Justice Kagan. This is on top of the fact that we have Judge Kavanaugh's 12-year judicial record to look at, while we didn't have any judicial writings to review for Justice Kagan. This is the most transparent and open Supreme Court confirmation process of all time. You're entitled to your own opinions about Judge Kavanaugh, but I don't think you're entitled to your own facts about the transparency of the confirmation process. We're working to make as many of the documents that we receive publicly available as soon as possible. It's common practice to receive documents as committee confidential. We've done it in each of the last 2 Supreme Court confirmations. Here, we're holding documents confidential until we can assure the public that we won't disclose sensitive, confidential information to the public contrary to the Presidential Records Act. My goal is to make as many publicly available as possible. I have instructed my staff to work with the legal teams for President Bush, President Trump, to waive committee confidentiality for specific documents that my colleagues would like to use at the confirmation hearing. This is also consistent with how the Judiciary Committee has handled this in the past. And of course, all of my Senate colleagues are welcome to review committee confidential documents at their convenience. We already have several computer stations set up for any senator to go at any time, 24/7, and read any of the documents produced to the committee. Simply get in touch with my staff. They will also make sure that each member has full access to a range of committee confidential documents. Senator Feinstein.
Mr. Chair.